Hi.
Say hi.
So let's discuss the landmark judgment that we just received from the Chennai High Court. There are a lot of views, and there is a lot of perspective from where you can look at to this particular case. So let's discuss what happened, a little bit of background, and then your approach and your thought process behind it, and how the judgment came around.
Sure, Utkarsh. So essentially, this judgment is about foreign filing license that one takes from the Indian Patent Office. Now, just to give you a very broad perspective of what a foreign filing license is. So, if a patent applicant or an inventor wants to file any patent application outside of India, there are two approaches to it. One is either you file a patent application first in India and then wait for 6 weeks, and essentially, if there is no secrecy direction being issued
Okay.
within these 6 weeks, you can go ahead and file a patent application outside of India, right?
Okay.
So let's suppose for some reason an Indian resident does not want to file a patent application in India, then what they can instead do is, submit their invention or provide a disclosure of their invention to the Indian Patent Office. Now, the Indian Patent Office essentially scrutinizes the invention to see if it is related to defense purposes.
Okay.
And one thing that could happen is that if it is in fact related to defense purposes, then they can issue what is called as a secrecy direction. In which case, there are several limitations in terms of what that inventor or the applicant could do. Which means to say that they cannot really go ahead and file any patent application outside of India if that secrecy direction is issued. On the other hand, if the secrecy direction is not issued, then they can go ahead and file the patent application without even filing a patent application in India in a foreign country.
Okay.
So the whole idea here is that whenever there is an invention or what probably is perceived to be an invention by a resident in India, before that information about that particular technology goes outside of India in the form of, let's say, a patent application in this particular case, the patent office and thereby the central government wants to kind of scrutinize this whole technology to see if it is related to defense purposes. And if it is related to defense purpose, then they would want to issue a secrecy direction. Okay. And if not, yes, you can go ahead and file it outside of India. So this whole case kind of revolved around that.
Okay.
Yeah.
Before we move on to the next part, so why do we even have this provision of secrecy direction? Why is it so important to have secrecy direction?
Right. So multiple countries, or I would say most countries, do recognize the importance of somehow scrutinizing new technologies before that information goes outside of the country, right? So, for example, a country like US, even they have such a provision. But however, the provision in the US is slightly different in the sense that they allow the applicant or the inventors to kind of scrutinize a certain technology to see if it is a technology wherein explicit permission is required by the patent office to take that information outside of the country, or they can by themselves kind of decide whether it is a technology where it has no consequence, so let's say a defense purpose, and then they need not even go and seek a permission, right? But India takes a very different approach to this. In India, that subjectivity is not really left to the patent applicant. They say that whatever the invention, even if it relates to a coffee mug, right? You give that information to us, we will scrutinize this. And based on our scrutiny, we will either say that, okay, I need to issue a secrecy direction, or they will say that, okay, there is nothing relevant to defense purposes, so you can go ahead and take it out, disclose this information outside of India. So the crux here is that, one wants to look at any new technology to see its relevance to defense purpose.
Okay.
So that is the spirit of the law, so to say. And that's kind of essentially, there is what is called as section 39, which essentially states about the provisions with respect to filing of patent outside of India. And then there is what is called as section 39, which talks about issuance of secrecy direction if it is related to defense purposes. And then you have what is called as section 40 that kind of talks about what happens if somebody were to not follow the provisions of taking a foreign filing permission as per section 39.
Okay.
So yeah, like I said, the crux here is to check whether it relates to defense purpose or not.
Okay. So this is like very specific to Indian residents.
Yes, it's absolutely specific to Indian residents. Even if one of the applicants is actually not a resident of India, so many a times you have situations wherein you have applicants from multiple countries.
Yeah.
So even in a scenario where one of the applicant is not really an Indian resident, then this wouldn't apply, and that kind of makes sense because the information is already out of India. Given the fact that one of the inventors or one of the applicants is in fact right now not even a resident of India.
Okay. Okay. So now we have a basic understanding of what the secrecy direction is. So now maybe you can give us a little bit of a brief disclosure of what the case is all about, the background of what happened, and then we'll move.
Sure. So this is a fairly interesting scenario from the context of secrecy or the foreign filing license. So what happened is our client filed a patent application in India to begin with, right? And subsequent to that, they went ahead and we filed a PCT application, which is an international application. So from that PCT application, there was a national phase application filed in the US. Right. So we had the Indian application, then the PCT application. So from that PCT application, there was a US national phase application that was filed. So eventually the Indian application also got granted. The US application also got granted. So at some point in time, there was this minor improvement that was made to this, what I would say, parent invention. Now, this minor improvement that was made was not significant enough to kind of warrant a fresh or a typical patent application, a standalone patent application.
Okay.
Since it was a minor improvement over an existing technology that was already covered by a parent application, now the inventors kind of decided that, okay, the best route would be to file what is called as a patent of addition in India and referred to as a continuation in part application in the US, which is typically a scenario wherein the improvement is kind of minor, and typically this improvement is probably novel as compared to your parent invention, but it might be considered to be obvious, right? So that's why the improvement is not very substantial. Now, when this improvement was made, they decided and went ahead and filed a CIP application, continuation in part application in US, right?
Okay.
So, and thereafter, they filed the patent of addition in India for that same improvement.
Oh, so you're saying the first application was filed in the US and then they entered India?
Yeah. So for the small improvement that was made, the first application was filed in the US and later on filed in India.
Yeah.
But for the parent invention, it was first filed in India and then went into US. So we did not have any problems with respect to the parent application because it kind of followed this route.
Yeah.
But for the improvement, we had the situation wherein, the improvement was first filed in US and then later on brought into India. And because something like this happened, for this patent of addition, which is the application for the improvement in India, the patent office came back and said that, well, you have contravened the provisions of section 39, which is the foreign filing permission that one needs to take for any application if that were to be first filed outside of India. And since we have, according to them, since we have not taken a foreign filing permission or not even either taken a foreign filing permission or should have first filed it in India, since we have, kind of contravened according to them. They said that, okay, now the provisions of section 40 kind of kicks in, which essentially states that in a situation like this, your Indian application will be considered as abandoned. So in effect, the Indian Patent Office essentially said that we are not going to grant you a patent because you have contravened this particular provision, and that's what kind of led to this appeal. Based on the decision from the controller, we essentially said that, okay, we need to kind of appeal against this decision because in our view, we had met all the requirements in principle and in spirit of all of these provisions.
Yeah.
And we initially went to the IPAB and then Intellectual Property Appellate Board,
Right.
which got dissolved. And later on, that particular appeal went to the Chennai High Court, and eventually we ended up having this judgment in our favor.
Okay. So what I see here is that, the first application, the parent application, was filed in India.
Correct.
So, and then we filed a PCT application,
Correct.
and then we entered US through a national phase.
Correct.
So, here we did not really have to, seek a foreign filing permission because the first application was filed in India itself.
Absolutely.
Right. So, let's say now, for any application, one without even filing it in India wants to file it in US.
Correct.
So seeks a foreign filing permission.
Correct.
So there, the patent office would, take the application into account and see if the technology relates to a defense technology,
Yes.
serves any defense purpose.
Correct.
Right. If not, then they would go ahead and give us the permission to file it in
Correct.
any foreign countries. Now that in this case we have filed the application in India, the patent office knows that the application does not relate to a defense purpose,
Right.
even though we have not filed. We have filed for a foreign filing license.
Right.
Since it was filed, it would be taken into account, and then they would have
Right.
scrutinized it.
Correct.
Right. So they know that this does not relate to any defense
Correct.
technology. So I think that is the main point that one has to consider before,
Right. Right.
based on our discussion here.
Right.
And then the next part is filing a continuation in part directly in the US
Correct.
without seeking for a foreign filing permission from the Indian Patent Office.
Correct.
Okay, so this is what happened,
Yes.
right? So now the application was abandoned, deemed
Correct.
to be abandoned.
Yes.
And then we filed an appeal with the IPAB.
Correct.
So since the IPAB has now dissolved,
Correct.
the Chennai High Court has
Yes.
took it up.
Yes.
Right? Okay. So what was your approach when the application was taken up by the Chennai High Court? What were the proceedings like?
Right. See, what kind of makes this case very peculiar is, or what kind of makes it slightly challenging to get a decision in our favor, is actually the wording of this particular section itself, which is section 39, which, I don't remember it verbatim, but essentially what it means is that they say that any invention,
Right.
or any application, patent application that has to be filed outside of India has to go through this process.
Correct.
Right. So the word any kind of plays a very, very crucial role.
Yeah.
Right. So when you kind of, look at this particular section verbatim, and because it has this word any, and it says that any application, so one would kind of assume, or one is probably inclined to kind of interpret this particular section that, okay, even a patent of addition, if it were to be the case, you need to go ahead and, seek a foreign filing permission or file the patent application as a patent of addition first in India, right? Yeah. So this terminology or the phrase any application kind of makes it challenging. Now, we had to kind of, add some meaning to it, or give some perspective to this phrase any application that is there in this particular section. So one, we had to kind of give this perspective based on what is the intention of the law.
Correct.
Second, based on essentially how the patent office itself has been implementing this particular law, right? Now there are multiple approaches that we took to debunk this whole phrase of any application. Now to begin with, now what we are saying is that there are what are called as divisional applications. Right. So typically in a divisional application, you file patent application in India. Typically, some of these applications which end up being divisional application essentially has multiple inventions, at least more than one invention in a single patent application. Right. So let's say you have filed something like that in India, and thereafter you file a patent application, corresponding patent application, let's say in US. Right. Now, since you had filed it in India, now thereafter you are going at and filing it in the US, you have not really violated any law.
Correct.
You have actually gone through the process. And thereafter, let's suppose at some point in US, they think that, okay, since my initial invention is actually covering like multiple inventions, right?
You mean the application covers multiple concepts?
The inventive concept.
Yeah.
In US, they might say that, okay, I will now file separate applications as divisional applications,
Right.
covering different inventions that were previously covered in the parent patent application, right? When they go ahead and file these divisional applications, if we were to kind of, interpret this law as is,
Yeah.
right? So essentially we are saying that, okay, even when you file those divisional applications in US, you should have come back to us and then, you should have taken our permission.
Right. Because the term any is very
Any
open.
means that, it's very open. So even in a divisional application, ideally there should have been the interpretation, and the resident of India should have taken permission even to file those divisional applications. Right?
Yeah.
To that, one would argue that no, that's not really required, because when you initially filed the parent application in India, that also covered all of this, multiple inventions. So we had kind of scrutinized this whole thing.
Yeah.
So that is why you did not have to file for, filing permission when you took up those divisional application.
Yeah.
Which means to say that we are now actually applying logic. To say that, okay, when I say any, it does not necessarily mean that, I will apply this whole, provision without putting any logic. And I will say that, okay, any application, you have to take a permission.
Yeah.
That's not the case, right? So we have already diluted that particular terminology, any, by applying logic to say that, well, you have given me all of this information.
Correct.
That was sufficient. I've checked all of these things, and that's more than sufficient. So we kind of said that, okay, now when you say any, doesn't mean that it can be any. We still have to apply logic and say that, okay, apply the spirit of the law.
Correct.
And the patent office has been doing that.
Right.
So that's one. So that was one of the ways in which we kind of argued to debunk this any kind of a thing. Then we took another approach, wherein there are many instances wherein you end up filing, let's say, a provisional application.
Right.
Okay. And then you file typically a PCT or an international application. Then you probably file it in a lot of other countries, and also end up filing a national phase application in India.
Yeah.
So that also happens many a times, right? Now we pulled out examples wherein you have a provisional application and then you have a PCT application.
Yeah.
Now the difference in the content between the provisional application and the PCT application is significant.
Right.
The subject matter that is added in that PCT application is significant as compared to a provisional application.
Yeah, that is one of the possibility. Yeah.
Yeah, and then that happens many a times, right? Even in those scenarios, the patent office has been all right. When eventually the Indian national phase application came in, the patent office never really objected to it by saying that, okay, from your we looked at your provisional application. Based on that, we did not raise any objection with respect to secrecy direction. Now, how did you go and file a PCT application that had a lot of subject matter which was not even covered in the provisional application, right? So the patent office never said that.
Yeah.
So which means to say that even with respect to the provisional application, the additional subject matter that comes into a PCT application or any subsequent application that is filed outside of the country, the patent office took a judgment and a right judgment to say that, okay, well, the provisional application, which is the core of, let's say, or which disclosed the crux of the technology, never related to defense purposes. How adding some subject matter over and above that would all of a sudden become relevant to defense purpose?
Right.
So they never bothered, even when additional subject matter was filed outside of India, right? So which means to say that even in these circumstances, the patent office is still applying logic.
Yeah.
Right? To say that, okay, there can still be circumstances. Previously, when we talk about divisional application, it was the same content that was going outside. Yeah. But here, it was actually, additional content that was going outside.
Correct.
So they still followed the spirit of the law to say that, okay, that is still fine, right? You had disclosed some portion of it. We thought that, okay, never related to defense purpose. You have now added more subject matter and filed this application outside of India.
Yeah.
And we are still very fine with it. We are assuming that even by doing this, you have actually practiced, or in spirit, you have met all the requirements that needs to be met under Section 39, which is the foreign filing permission, right? So when the patent office has been, one, not really applying any application as is, secondly, is also using logic like the one that I mentioned, right? To say that, okay, now you are still following the spirit of the law. Now, why are you now not following the spirit of the law when it comes to a patent of addition? Because even in a patent of addition, the example that I gave from a provisional to, let's say, a PCT application, it's very similar to that, right? You have a situation wherein the parent application never really related to, defense purpose. Yeah. Now, how did a patent of addition, all of a sudden become relevant to defense purpose?
Dependent on the parent application.
Which is essentially dependent on the defense, on the parent application. Yeah. So we used all of this logic, and subsequent to that, we also, said that, okay, see, when we speak of patent of addition, as we know, it kind of expires with the parent application. Right. So which means to say that a patent of addition from the filing date itself, it does not necessarily have the 20-year life. Yeah. The 20-year life actually starts from the parent application. Yeah. So the applicant is actually compromising on that life because it is just a modification, right? And then when we filed a patent application, you know that patent of addition can be an improvement or modification of your parent application.
Correct.
You accepted that as a patent of addition.
Yeah.
You examined that whole application. You never raised an objection to say that no, this is not related to the parent application. So you accepted that it was in fact an improvement or a modification of a parent application. Yeah. So when you are agreeing to all of these things, now why are you using a completely different logic, which is completely opposite or deviates from your well-established ways of applying logic in all of the other cases, right? So that is the whole approach that we kind of took to say that, okay, you need to kind of practice law based on the spirit of the law, and you cannot be applying law differently to different circumstances. So this is very similar to the circumstances that where you have applied law very differently, and that was the approach that we kind of eventually took.
Okay.
Yeah.
So what was the judgment like?
So the judgment is also kind of interesting, and I think it's a welcome kind of a judgment. So essentially the judgment says that, okay, even in a patent of addition, do follow that whole process.
Okay.
Right. So which is if even in case of such improvements, if you want to file that improvement outside of India first, you take a foreign filing permission.
Okay.
Right. But what is interesting is that, okay, now even if somebody were to not do that, right, in these circumstances, that does not necessarily mean that you should consider that application as abandoned. Right. So don't go to that extent of abandoning or rejecting the patent application based on this particular provision, right? Okay. Because the lapse that has happened from the applicant is more procedural,
right?
Right. But from a principle or as a spirit of the law standpoint, the applicant has in fact, followed all of this, right? So it has gone back to the controller to, kind of, dispose this off based on this particular judgment, and we are very hopeful of a grant. But this is what we are kind of fighting for, that it should not result in abandonment. So essentially, there are provisions within the Patent Act that gives the power to the controller to kind of take certain decisions based on certain, I would say judgment, wherein you file for we kind of, file for a petition and, request the controller to kind of, look at this. And then on the basis of the judgment, obviously, we think that the controller would be inclined towards, withdrawing this particular rejection and then allowing a patent to be granted. So the judgment, in short, essentially says that, okay, if you are, even in case of a improvement, when you do that, you go ahead and seek a foreign filing permission. And if somebody does not do that, the repercussion of not doing that cannot be the complete extreme of rejecting the patent because it is deemed to be abandoned because of the contravention, right? So that's what the judgment is all about.
Okay. So while you were explaining, you also spoke about, the approach of filing a provisional application followed by a complete specification, where, the content of these two applications could be substantially different.
Correct.
Right? So does the patent office examine the provisional applications at all? I mean, without even having filed the complete applications?
So the provisional application, yes, it is examined to the extent of determining whether it is relevant to secrecy direction or not.
Okay. Yes. So the patent office does go through.
So that is done because if at all they want to raise secrecy direction, issue secrecy direction, they need to do it within 6 weeks. And if they don't do it, it's an automatic route wherein the assumption is that yes, it does not relate to secrecy direction. The applicant can take it outside of India. So examination to the extent, or I would say due diligence to the extent of checking whether it relates to defense purpose or not, is also done on a provisional application.
Okay. So,
I mean, had this judgment kind of gone against us, given the arguments that we had posted, saying that, well, even in a provisional, there is not much of content, and then you have a PCT application. Now, assume a judgment that would have said that, okay, patent of addition has additional subject matter, right? You had to take a foreign filing permission because you did not do that, it's abandoned. If that were to be the judgment, just imagine the consequences in view of the arguments that we had placed. The consequences would have been that you have to take foreign filing permission by filing the exact patent application, the exact content in India first, or when you seek a foreign filing permission, you have to prepare the exact document and give it to the Indian Patent Office. And only when that foreign filing permission is sought from that exact document, with no additional subject matter being included thereafter, that would have been the standard process. So from that point of view, this judgment is a very, very reasoned judgment, which kind of balances it out.
Yeah, they have considered all of the points that would have been considered. So we saw that the Patent Act itself is like very the terms that are used in writing the Patent Act contains very broad or open terms. So what is your view on such?
So basically, whenever any law or act is drafted, rules are drafted, right? It is very difficult sometimes to draft something that would be applicable to all the scenarios that might come up, right? So that is why there is whenever you apply law, it has to be applied in principle and not necessarily just read through it and then apply it without really applying one's mind to it, right? So from that point of view, the phrase any application is slightly dangerous, right? Now, given these scenarios of how things have been applied even previously,
Yeah.
right, and given the current judgment, there can be as and when there is an amendment to the act, there can be some kind of an explanation that could be added
Yeah.
to something like this, or in any case, there is this particular case law that one could use,
Yeah.
and decide on how they would want to proceed.
Yeah.
So lot of circumstances need to be thought out. Some of these terminologies that are used in the act might become slightly tricky in certain circumstances.
Yeah.
So yes, I think with respect to this specific thing, there is a requirement of some kind of an amendment or some kind of an explanation that should ideally go with this particular provision within the act.
Yeah.
At the same time, if you were to look at a comparative law in US, so US law essentially states that, well, if you have, like I said, US does not necessarily require you to kind of, take a foreign filing permission for all kinds of inventions. But yeah, in some cases, yes, you need to take them. But essentially what it states is that, okay, if there is some kind of an invention where you did not need to take any kind of a foreign filing permission, or if there is some kind of an invention where you have taken a foreign filing permission and the permission has been granted, and then you start making some modifications to them, alterations to that particular thing. When you make certain alterations or modifications to them, you don't really need to come back and again take a foreign filing permission.
Right.
So that is a very, very well-balanced approach, right? So a provision like that, if it were to be included here, saying that, okay, well, you have taken a foreign filing permission for some basic or a parent invention or a provisional invention, now you are starting to make some modifications to it. But essentially the technology kind of remains, the crux of the technology kind of remains the same. So you don't really have to keep coming back to me and then seek foreign filing permission. Right?
That approach is actually very logical.
It's very logical. Otherwise, it is extremely bureaucratic. Lot of things are left to the interpretation, like what happened in this particular case. So provision of that nature, if it were to be added, I think it makes life easier for inventors and patent applicants. At the same time, also, protecting the interest of the government, which is to ensure that things that are related to defense purposes do not really grow out of the country without scrutiny, right? It is kind of solving both by including a provision of this nature. So that's probably something that could be thought about.
And also kind of it reduces the timeline of, the entire patent process.
Absolutely. Essentially, it makes the life easier for innovators. Right. They need not keep coming back to the patent office. Reduces the burden of the patent office, because in any case, they are going to end up, giving a license for technologies that are like not even distantly related to defense purposes. So it kind of works out for everybody. At the same time, actually protecting the interest of defense related inventions not going out without scrutiny.
I think we had a pretty detailed understanding of what the entire judgment was about. And we also now have clarity on how one can interpret the sections in the act. And one needs to take into account the context where you're going to apply this particular section. So I mean, there needs to be a little refinement to the Patent Act itself, the way it is drafted, because at the end of the day, it should be inventor friendly, because you need to push the inventors to come up with more inventions, and then that
also at the same time, see, when this happened, at least from an applicant standpoint, or if somebody is just reading the act, it looks like there is absolutely no way of getting this through, because of the phrases that are used in the Patent Act, and absolutely no case law to the extent that I know of, and I'm pretty sure where such a circumstance has been dealt with in favor of the patent applicant, right? So sometimes it's really about how we kind of push the envelope, how we kind of interpret the law, and we kind of think out of the box to kind of bring some perspective and then start pushing what is in favor of whom we are representing, right?
I think this judgment actually kind of, gives you the base or the foundation for, the next
True.
upcoming, cases.
True. And not just this, but I mean, I would say in general, when you're dealing with, let's say, any kind of scenario where there is no precedence, or even when there are precedents, it's really about, how you end up looking at this, how you end up crafting your arguments, how you end up using certain things to your advantage to kind of ensure that your client is best represented, and then you get a favorable outcome to it.
Yeah. Okay.
Okay. Thank you. Thanks for the podcast. I think this was
I think this was very informative, and then
hopefully,
we had at least I had a great time, listening to it and then getting in depth.
Even I had a great time kind of exchanging these thoughts. So hopefully others will find this useful.
Yeah.
Thanks a lot.
You.
Yeah, thanks. Bye.